This is Bentley Tolk with the ERISA Litigation channel. I'm here on behalf of myself and Mary Ann May with another episode. Today we're going to be discussing a Seventh Circuit case that talks about proper defendants under Section 502A1B of ERISA. And I'd like to thank Mary Ann May for her help with this case. This is the Larson v. United Healthcare Insurance case. It's a case that came out on July 26, 2013. Just briefly, the facts are that it was a class action against 6 health insurance companies, and the plaintiffs were alleging that the insurance companies were violating Wisconsin state law by requiring that there be co-payments for chiropractic care. Now, Wisconsin law requires health insurance companies to cover chiropractic care on an equal basis as other forms of medical care for the same condition. Since the plans were employer-based plans, the plaintiffs sought relief under Section 502A1B for recovery of benefits and under Section 502A3 for breach of fiduciary duty. The district court dismissed the action under Rule 12b-6 for failure to state a claim upon which relief may be granted, and the district court held that insurance companies are not the proper defendant when there is a claim for benefits under Section 502A1B. The district court also noted that a claim for benefits due under an employee benefit plan ordinarily should be brought against the plan itself. And the district court held that insurance companies are not acting as fiduciaries when they set their policy terms, including the chiropractic co-payment requirements. Of course, there was an appeal on that decision, which brings us to this case with the Seventh Circuit. The Seventh Circuit held in the Larson case that plaintiffs can bring an action under 502A1B for benefits required by state law when those benefits are not specifically listed in the plan documents. When a plan includes an insurance policy, the contract terms that are mandated by state insurance law actually become plan terms. A claim for benefits under Section 502A1B can be brought against an insurance company, according to the Seventh Circuit. Although the general rule is that a claim for benefits has to be brought against the plan, there's nothing in ERISA that prevents bringing such claims against an insurer. Such a cause of action for benefits must be brought against the party that has the obligation to pay. In other words, the obligor is the proper defendant in an ERISA claim to recover benefits. The Seventh Circuit also held that where the plaintiff alleges that she or he is a participant or beneficiary under an insurance-based ERISA plan, and the insurance company decides all eligibility questions and owes the benefits, the insurer is a proper defendant in a suit for benefits under Section 502A1B. Which I must say, as someone who does defense, I would clearly like to limit it so that it would not be the insurance company, but that's at least where the Seventh Circuit went on this. The third holding is that plaintiff can't bring a claim for breach of fiduciary duty for imposing co-payment requirements for chiropractic services. Imposing policy terms, according to the Seventh Circuit, isn't a discretionary aspect of claim administration, and therefore it's not a fiduciary act. Now, in terms of the reason of the holdings, the Seventh Circuit noted that a claim for benefits under 502A1B is essentially a contract remedy under the terms of the plan. It can be difficult to identify who the plan is, and because of that difficulty, courts sometimes equate an ERISA plan with an insurance policy. The Seventh Circuit mentioned the Supreme Court Unum case, which held that when an ERISA plan includes an insurance policy, the requirements imposed by state insurance law become plan terms for purposes of claims under 502A1B. Otherwise, ERISA preemption will leave the states powerless to alter the terms of the insurance relationship in ERISA plans, because insurers could displace any state regulation simply by inserting a contrary term in their plan documents. According to the Seventh Circuit, Section 502A1B doesn't specify who can be sued or who is a proper defendant. Thus, a claim has to be brought against the obligor, in other words, the party with the obligation to pay the benefits. When a plan is implemented by insurance and the insurance company decides contractual eligibility and benefits questions and pays the claims, the insurance company is the obligor. When insurers have both the authority to decide all eligibility and benefits questions and the obligation to pay the claims, contract obligations run directly from the insurer to plaintiffs. Turning now to Section 502A3, the claim for breach of fiduciary duty, the threshold inquiry is whether the defendant was performing a fiduciary function when taking the particular action at issue. Here there were no allegations attacking the discretionary aspects of claim administration. There was no challenge to individual eligibility and benefits determinations. Instead, the complaint targeted decision-making regarding policy terms. In summary, the Seventh Circuit took an expansive view as to who can be a proper defendant. In other words, it's the obligor who can be the proper defendant. Courts will have to conduct case-by-case determination in the Seventh Circuit to determine who is obligated to provide the disputed benefits. In other words, whether the disputed benefits are obligations of the plan itself or of some other party, such as the insurance company. Well, that's enough about proper defendants for now. We will carry on with future episodes. For Marianne May, this is Bentley Tolk for the ERISA Litigation Channel. Thank you.